the same arrangement will be there. There will be 5 or 6 judges on the dais. You will be sitting just like this. Feel at home, firstly. Don't put any stress on your mind. Say to yourself that you have come to some of the relative for having cup of tea. Nothing. Don't put any stress on your mind. Whatever the question is, if you are not knowing, there is no harm in saying that, sorry sir, I am having no material to explain this question. But if you are having some material, you can give some to some extent the answer. Then you can say that I am not having sufficient material to give. Then of course, they may ask you that say whatever you are doing, then explain that. Are you please come to this side? Yes, come to this side. Yes, Palika. You might have discussed term set off in civil law. What is the meaning of set off? And where it has come in CPC or in some other acts?
Sir, set off is provided under CPC under Order 8 Rule 6, and sir, the set off is provided for the sir.
Explain that. Try to explain. Don't be afraid.
Yes, sir.
Here, if you want to explain in
party-
Punjabi,
Yes,
in
sir.
Punjabi or Hindi, you can use those words
Yes,
also.
sir.
There is no harm. But if the board says that speak in English, then you will be bound to speak in English. Then you cannot use that. Otherwise, you can use that Punjabi or Hindi also.
Yes, sir. Sir, it is provided under Order 8 and Rule 6 of the CPC. Sir, it can be claimed by the party only for the fixed sum of the money.
Can you give some example, small example?
Yes, sir. Sir, for example, A files a suit against B for the amount of the 10,000 rupees, and sir, then B files in his written statement and claims a set off for the amount of the rupees 5,000 rupees. Sir, then this will be sir. Then
All
this.
right. All right. What is the meaning of this term set off in criminal law? You have read in
Yes.
criminal law also?
Yes, sir.
Yes.
Sir, in criminal law, sir, it is provided under Section 428 of the CRPC.
Exactly.
Sir, it means, sir, adjustment of the imprisonment. Adjustment of the imprisonment the accused has been. सर मतलब जो उन्हें अंडर ट्रायल के दौरान जो उन्हें अपनी imprisonment ਕੱਟ ਲਈ ਹੈ ਸਰ
Say in Punjabi, whatever. Don't stop when you are having answer in your mind.
Yes.
Don't stop it. Explain that. Explain. Make it clear.
सर
Make it this clear set off in criminal law under section 428 of CRPC.
yes sir
Reiterate that. Explain again.
sir set off is provided under section 428 of the CRPC. Sir, when the sir, for example, accused ਦਾ trial ਚੱਲ ਰਿਹਾ ਆ ਤੇ sir so sorry sir.
It comes in operation after the punishment is imposed or during trial.
Sir, during trial.
During trial.
Yes.
The order is passed by the court during trial or after the trial? No, it is after the
Sir,
trial.
after the
When
trial,
the
yes,
court
sir.
has convicted the person and it has given punishment,
Sir,
then the court will write
punishment will
there
be adjusted after.
that this much imprisonment which he has already undergone should be set up against the term which has been imposed. Now there are two words, holding over and holding out. Can you explain that? Holding over, it is the term in which act. Have you ever heard that these
Yes,
words?
sir, I I have heard. Sir, it is provided under Indian Partnership Act.
Holding over or holding
Sir,
out?
holding out.
Holding out.
Yes, sir.
In which section?
Sir, section 28 of the Indian Partnership. 28.
28?
8.
8, exactly. You are right. So what it says? Do you know that or not?
Yes, sir. I know
Give
that.
some example. When you are knowing the answer, don't stop. Consume the time. Maximum time you can consume. Because once you know the answer, then don't stop. Otherwise, they will start asking more questions. Explain that.
Sir, explain करना क्या है?
Alright. Holding over.
Sir, holding over I know.
You have read TP.
Yes, sir.
In TPA there is one section, 116,
Yes, sir.
which is talking about holding over. Can you explain now? Still not. Holding over mean when a tenant, his tenancy has been terminated, but still he is residing there, he is occupying the building and he is paying the rent also.
Yes, sir.
Then we say that this tenancy stands again resumed. It will be deemed to be a tenancy. Yes, Kamala.
Yes, Palika, explain the difference between acquittal and discharge.
Yes, ma'am. Ma'am, in the case of the acquittal, the accused will be permanently released from the offence. And in the case of the discharge, he may again be called by the court.
Yes, Palika, we are having many interviews on this website. Do watch all of them. That how students, they were trained to give a quick reply. Devote some time. It will increase your knowledge also. It will build up some confidence in you. Those videos will motivate you also. Many videos. Like you are sitting here. Like you, there are many. You might have seen earlier also.
Yes, sir.
You see, you were here when we conducted
Yes,
some
sir.
interviews. Then you have seen all the students, they gave reply. Their flow was so quick. How make that flow? She is asked about this discharge and acquittal. Can you refer to the sections also? That these are the sections which are dealing with discharge and acquittal.
So at that point of time, I do not remember the exact sections.
Okay. At that time when you were studying here, you were cramming all the sections.
Yes, sir.
That these are the sections of warrant trial by the judicial magistrate. These are the sections which are trial in the court of session also. And you was remembering the sections, all the sections relating to summon cases tried by the judicial magistrate. Yes, sir. One question.
What is the process to compel appearance of person by the court
Ma'am, there are various processes to
under
compel.
CRPC?
Ma'am, there are various processes to compel the person before a court, like summons, through warrants, and through proclamation, and by attaching of the property of the.
You are talking, Palika, about proclamation.
Yes.
Where it has been explained and say something about that. Proclamation.
Sir, it is provided under section 82 of the CRPC. Sir,
Explain elaborately what is section 82.
Sir, proclamation is issued against the accused person when he is not attending the. Sir, explain करना. Sorry, sir.
Try to speak quickly because they will expect it from you to give quick reply to every question. You are having ample time. Your interview is on which date?
Sir, 4th of October.
it is sufficient time is there, try to go to the court and to speak out before the judge in some arguments also, with the advocates also. Try to meet the relatives also. Become a talkative person. They should say that she is very talkative. No, it is the time to be a talkative. Because in High Court, they will require answers. And this will not serve the purpose. You can get much more marks if you explain the things quickly. Now, Section 82 is Sahar will explain. Listen to it. Yes, sir.
So, proclamation is issued by the court when the accused person, if despite of being summoned to the court, has not come to the court. And the court, even after issuing warrants, has found out that the person is not available and can't be found to be brought to the court to face the charges and to face the trial. Proclamation is issued by the court by issuing a notice which is attached on his address, like outside his address, on a conspicuous part of the property, that everybody who's passing through that property can see that a certain person is wanted by the court to come to the court and hear the proceedings. The same is also issued in the local newspaper. And once a proclamation is issued, it can also be issued by the beating of the drum in the vicinity of the place where he usually works or he resides. So by this process, the court basically has made it known to the public. And it is presumed by the court now that this person has knowledge of these summons, irrespective of the fact that at some point maybe the summons weren't reached, or even when the warrants were being executed, they were not executed, or they could not be executed because his address was not there with the person, or he was there, or he was in some other place. But now people who know him, they also are aware that there is a particular complaint filed against this person, so this person needs to attend court. And after a proclamation has been issued, his property can also be attached in this case to compel his appearance in the court, because the court just doesn't want to hear the suit and file or like issue a sentence against him. He also needs to be heard on the case. So it is.
Palika, you might have recollected. You should speak like this. Try to do that. Come daily to the second. We will bring you daily on the stage to speak something. Cram something at home so that you can deliver the lecture for 10 minutes, 5 minutes, whatever the subjects, in order to remove your hesitation. Because you will have to get good marks by giving appropriate answers. Can you explain criminal complaint in CRPC, which section is dealing with the institution of criminal complaint and before whom it is filed?
So when the criminal complaint is filed before the magistrate, so then the magistrate first of all can, before taking the cognizance,
It is filed under which section of CRPC?
sir, it is filed under 200, section 200 of the.
Yes, section 200.
Yes, sir.
What is the procedure of that?
Yes, sir.
What the magistrate will do?
Sir, when the complaint is filed before the magistrate, sir, first of all, the magistrate can, before taking the cognizance,
Say everything with confidence and with a loud voice, so that nobody should go ahead to listen to you. That's what she is speaking. Speak loudly in such a way that everyone is audible to all. Yes.
Sir, suppose when the complaint is filed before the magistrate, sir, magistrate first of all, before taking the cognizance, he can order for the investigation under section 156 subsection 3 of the CRPC. And sir, if he is not giving the order under section 156 subsection 3, then sir, he can examine the.
You are referring to this section 156 subsection 3. Can magistrate send the case to the SHO in a non-cognizable offences?
Can the magistrate send the?
Non-cognizable offences. Complaint has been received by the magistrate. All the offences are non-cognizable. and he wants to send it to the SHO,
Sir,
police station, to register an FIR under section 156, subsection 3. Can he do?
Sir, I think no. In non-cognizable offences, a magistrate cannot do.
Only in cognizable cases he can do that. Otherwise, he will not send. Alright, then what action he will take? Suppose he is not of the opinion that this should be sent to the SHO for the registration of FIR. Then what he will do?
Sir, then the magistrate, before the issue of the process, he will, sir, examine the complainant and the witnesses, and if he is of the opinion that then the process should be issued. Then after the examination of the complainant and the witness, he may issue the process like summons or warrant. And sir, after this issue of process, the parties will appear in the court, and after that, sir, after the taking cognization of the offence, the evidence will be start.
Evidence will be started under which section? When the accused has put his evidence. Then what the magistrate will do? Accused has come in the court. The first action is whether he should be released on bail or not. Suppose he has been released on bail, then what next action he will take? Magistrate will do what? And under which sections? When you were studying here, you used to give quick answer to all these questions. Why is that? Why is your copy which has been maintained by you, that will suffice? Go through that and you will be commanding over that. Yes, I have one question.
Under section 320 CRPC, a list of compoundable offences has been given. Can you tell us what are compoundable offences and whether in any case a non-compoundable offence can be privately compounded by the parties?
So section 320 of the CRPC dealing with the compounding of the offences. Sir, under this section there are basically two tables. Section 320 subsection 1 deals with the compounding of the offences without the permission of the court, and section 320 subsection 2 deals with the compounding of the offences with the permission of the court. Sir, like section 323 of the IPC, this is a compounding of the offences without the permission of the court. Sir, like in some cases, like non-compoundable offences, like section 307 of the IPC, like attempting to murder. This is a non-compoundable offences which cannot be compromised even with the permission of the court. But in exceptional circumstances, the High Court can use its inherent powers under section 482 of the CRPC can compound these offences also.
Can High Court compound the offence? Answer will be absolutely not. No court can compound the offence. High Court may quash that.
Quash the proceeding.
It may quash that. Many times it happens that the lower court, there are some cases where the parties have compromised. For example, Rule 98A, that is non-compoundable. But husband and wife, they have made a compromise. Now the only remedy is to go to the High Court under section 482 or quashing that complaint. There is no other provision which can compound the offence. There is no such. Yes, Palika, you are knowing section 167 of CRPC, default pay. What is that default pay? Can you explain elaborately?
Yes, sir. Sir, default bail is that bail when the police officer has failed to file the charge sheet within the specific period of the 60 days or 90 days. Then the accused person can this bail as a matter of right. So this is default.
In which cases we have to calculate 60 days? In which cases we have to calculate 90 days?
Sir, where the imprisonment is up to 10 years, then there will be 60 days, and where the imprisonment is more than 10 years or life imprisonment or death, then there will be 90 days.
Suppose in some offence there is a imprisonment which has been written that the imprisonment should not be less than 10 years. Then it will be period will be 60 days or 90 days.
Should not be less than 10 years.
Imprisonment is not less than 10 years. It means minimum imprisonment will be 10 years.
Sir, it will be 60 days.
60. Go through that 167. Because they have specifically written these words that they are to count 90 days, not 60 days. Yes, Rishabh.
Under which circumstances murder converts into culpable homicide?
There are various circumstances when murder converts into culpable homicide. It is mentioned under section 300 of the IPC. Sir, when the murder is committed under certain grave and provocation and excessive sudden fight and quarrel, and there are various cases mentioned under section 300.
But more, there are 5 exceptions.
Yes, sir.
Can you explain
Exceeding
all
the
five?
right of the private defense.
Yes. What others are also? There are 5 exceptions.
Yes, sir.
Can you explain any more? Try to explain that. Alright.
Can you please explain the expression suit of civil nature?
Suit of civil nature.
Sir, procedure of
Suit of civil nature. You have written at least 10 pages in your copy over this, that these are the suits of civil nature. Where it has been provided this word, suit of civil nature.
Sir, it is provided under section 9 of this constitution.
Please explain that these are the civil suits, the suits relating to this of civil nature. Give some example that this is the dispute of civil nature.
So, for example, there is a dispute regarding the land between A and B. This will be the suit of civil nature.
Go through that. You are having copy. Make the base your copy for preparing it. Nothing else. There is no need to touch anything else. Go through the copy only. You will be having that. Because everything has been written by you in your copy. It's covered.
During evidence in a court, the court refused to admit certain evidence. Whether against such refusal a revision can be filed and under which section it has been provided.
Have you understood the question?
Suppose a person is going to admit evidence in the court, but the court refused to admit that evidence. Whether a revision can be filed for admitting that the evidence in that suit?
Ma'am, I think the reason cannot be filed.
Okay. Under which section it has been provided? Can you explain? It has been provided under section 167 of Evidence Act. No new trial. or
Can you explain that heading of 167?
Improper admission or rejection of evidence.
Exactly. Explain that also. Put some stress on mind, some question is, when some question is there. You are knowing the answer. Don't evade that. Try to give answer. One thing is more, don't try to give wrong answer. Because everyone is having full knowledge. There also, all judges will be having full knowledge about each and every concept. Therefore, don't try to bluff. Feel sorry if you are not having knowing answer. Now you are knowing the heading You can expand that. You can explain also. Can you explain this? What is improper admission and a rejection of evidence?
So, no,
All right. Kavajit, can you explain?
Sir, suppose a person want to admit an evidence in their suit, but the court refused to admit that evidence. Later on, that evidence cannot be admitted, and no new trial can be initiated for admitting that particular evidence, because unless there is any injustice caused to any party.
And the court will see that if the evidence has been denied, refused, had this evidence come on the record, there would not have been any difference of verdict. Verdict would have been the same. Then the court will not allow it. Yes, sir.
So today you're facing a panel of interviewers in front of you and we're asking you a lot of questions. Tomorrow you're going to be sitting on a seat of a judge and you're going to be facing a lot of cases, a lot of different circumstances. First of all, have you been in a hectic work environment before? And how do you manage that work environment and that stress level at that point to stay composed and to give the right judgment and the right decisions in that situation?
Sir, I think I have so many qualities. I am very punctual and I am very hardworking. And
And in the habit of giving quick reply, say that also.
sir, and I think
Try to say this also. That I am having good habit in giving quick reply to every question. Say this also. Build up this confidence in you.
Sir, and I think I have a very good habit to giving quick replies to anybody, and I think I am the person who can do justice with this post.
And today also you faced a lot of positive, constructive criticism, like hearing this and you being told to learn a few things. So tomorrow if you're sitting on your seat of a judge, you have the authority and there is an advocate in front of you who's arguing a point with you and your opinion on that point is different from his. But what he is saying is the right decision. So how would you go about it? How would you deal with that kind of constructive criticism?
Sir, I think the judge is confined to the law only. So the judge will see the matter according to the legal point of view only.
Suppose you are sitting on the seat of the judge, you have been selected, and somebody he has made some insulting remarks in the court, and you want to take action. How you will take action?
Sir, I will take action as a contempt of court. Sir, I will return a.
Can you refer to some section? That this is the particular section where I will take action. Section of like this.
Sir, I do not remember the particular section.
Okay. My previous students they will give reply to that. Manpreet, you are remembering or not?
Sir, I'm
Sahaj, you will give 228. Section 228, very important. Insert to the presiding officer, to the court, when you are conducting judicial proceedings. Then how you will take action against? If you want to give imprisonment immediately at the spot, still you can give that. Can you refer to some sections? That which sections should be adopted? Which sections will be applicable in such a situation? 340, I have given elaborately that exhaustive lecture on 340. Under 340, you have to conduct the inquiry and you have to take action. You have to try, you have to take cognizance in the court itself, and you can convict him, you can give punishment also. while imposing some fine, maybe 100, maybe 200, up to 200. Go through that. Have command over this. I ask one question.
Whether SRE can be granted for enforcement of criminal law.
No, ma'am.
Yes, Rishi.
What is mistake of law and mistake of fact?
Where it has been provided in which act?
Sir, it is provided under Indian Penal Code. Section 76 is talking about the mistake of fact. Sir, am I right?
No, you speak. Don't ask this question from the interview board. They will assess you. If you are right, they will give marks. If you are wrong, they will not give them.
Sir, I think it is provided under Indian Contract Act. Mistake of
Indian?
Contract Act.
It means you are not sure whether it is it is mistake of fact, mistake of law, or it is relating to IPC also. You are telling the right portion of the sections. Yes, I am.
Can you, so section 101 deals with burden of proof and section 102 also deals with burden of proof. Can you tell us the difference between those two sections?
Yes, sir. Under section 101 of the Indian Evidence Act, the burden never shifts. But under section 102, the onus of proof is continuously shifting.
And in 101, on whom does the burden of proof lie?
It lies on that person who asserts any fact or claims any.
And 102?
102, under section 102, it will shifting on that person who fails to prove.
We're saying the right thing, but missing out a few
Oh,
words.
yes, Palika, you explain what is the difference between inquiry and investigation by the police.
Sir, investigation is always conducted by the police officer for the collection of the evidence. And sir, inquiry may be conducted by the judicial magistrate or even by the police officer.
Inquiry can be conducted by the police officer
Sir,
also,
it is conducted.
as per the provisions of CRPC.
Sir, inquiry is conducted before the framing of the charges. And sir,
When inquiry starts, can you give some point that this is the point when inquiry starts? Keep one thing in mind, that when an investigation is over, police report is presented, now the inquiry starts. It is a judicial magistrate who will conduct the inquiry for the purpose of framing charge, for the purpose of trial also.
For which acts, in spite of the criminal acts and mens rea, the person is not held liable. Can you explain some instances? There are two instances I can give you.
please explain the question.
For which acts there is a mens rea, criminal mens rea in the mind of the person, there is an intention to do a crime, but in spite of the mens rea, the court do not give any punishment to that, and the person is not held liable for his acts.
Ma'am, like there are general exceptions mentioned under IPC, like when the person is of the unsound mind, when the child is of the 7 years. These may be the examples of.
Particularly acts of slight harm, and when the person is causing anything in an act in which he is defending his body, private defense of body and property. Because they are, you have talked about it, person of unsound mind and the person who is underage, there is no mens rea, we cannot establish that.
Alright, Palika, if the suit has been dismissed in default, can it be restored?
Yes, sir, it can be restored.
Tell us the provisions that in which circumstances it can be restored.
Sir, it is provided under Order 9,
The rule?
Rule 3 of the CPC.
Yes.
Uh,
Dismiss in default. it can be restored. Can a new suit be also filed? If it has been dismissed under Order 9(3),
Yes, sir.
in all the cases, if the suit has been dismissed in default, in all the cases it can be restored and a new suit can be filed.
No, sir. In all the cases, it cannot be fresh suit cannot be filed.
In which case, no new suit can be filed when the suit has been dismissed in default. Is there any case?
Yes, sir. I know, but I am unable to recall.
If the suit has been dismissed in default under Order 9 Rule 8,
Yes, sir.
then whether new suit can
No,
be
sir.
filed.
There is a bar.
Remember these very familiar rules, familiar orders, which every advocate is having finger stick that this application can be. Now suppose if the defendant has been proceeded against X party and X party decree has been passed. Now defendant, he wants to avail some remedy. He wants to get that decree set aside. Can you tell what are the remedies with the defendant?
Yes, sir. Sir, he will have to show that there are some reasons that.
Where the remedy has been provided?
Sir, it is provided under Order 9 Rule 13 of the CPC.
Yes, say firstly this thing also, Order 9 Rule 13, which is one of the best remedies we can say. He can move an application. Suppose if he does not want to move the application, then he wants to avail some other remedy.
Sir, he can go for appeal.
He can file an appeal also.
Yes, sir.
Then
Sir,
he can file a review petition also,
yes, sir.
because there is a provision for review petition also. Alright. Yes, Rishal, one question.
In which circumstances civil judge return the plaint?
When the plaintiff comes in the does not come in the appropriate court, then the magistrate.
Yes, Palika, one thing, try to speak loudly. Don't remain confined to your, try to. That is why I say you come to the classroom for some days after preparing some topics, so that you can you can freely, with good flow, you can speak out whatever you are having knowledge. Yes, no, he has asked one question, that in which circumstances the plaint is returned.
Yes, sir. So it is provided under Order 7 Rule 10 of the CPC. Then if the plaintiff has come in the wrong court, then the court can guide him that he should be comes to this appropriate court. And
Can court transfer the case to that court? For example, suit was to be filed at Ludhiana, but civil suit has been filed at Jalandhar. Can Jalandhar court get the case transferred to Ludhiana court?
sir, I think yes.
With regard to return of plaint, it cannot be transferred. Plaint has to be returned to the person for the purpose of taking the plaint to that court. There is absolutely no chances of transfer of cases. Yes, Palika, if somebody has committed bailable offence, how he can be released on bail? Tell us that. And which are the provisions which are dealing with such a process?
Yes, sir. Sir, if the person has committed a bailable offence, first of all, he can claim the bail as a matter of right. Sir, it is provided under Section 436 of the CRPC. Sir, suppose if the person has not filed this bail even after the 7 days, then this person can be treated as an indigent person, and he should be released on the bail as an indigent person.
Who can grant the bail? Who are the persons competent to grant?
Sir, any police officer or the court can grant a bail in bailable offences.
Yes, sir.
Do you recall what Section 6 of Evidence Act says?
Yes, sir. So Section 6 of the Evidence Act is deals with the res geste, that is things done.
Can you give an example?
Explain that. Not only one word will not serve the purpose. One word will serve the purpose in preliminary exam. But here in interview, they want that they will tell you one word and you have to explain that, expand that. That will be the art which you must learn before going before the interview court. What is that section 6?
Sir explains problem.
Facts relating to the same transaction, expand that also. Alright, Palika, next time we will hope you will be quite ready, well prepared for that. I will also request you to your dad also. He will make you a master of this because he has understood that what will happen exactly in the same way you will face that. They will ask this type of questions. Question may be easy, question may be difficult, but if you are having command, you can have command only if you go through the copy. Your copy only will suffice for this purpose. Right, all the best in the future. Yes, students, we will get together after 10 minutes break.